everyone joining in today. My name is Ray Walters. I'm with Epi Compliance, and I'm joined today by my co-host, Mr. Jose Delgado. Uh, Jose brings over 20 years of experience in healthcare consulting. Currently owns and operates a mental telehealth clinic. So always appreciative of Jose's insights. And to Jose's point, yes, a little more of a drier topic. We've been covering a lot of OSHA this past month. We decided to switch it up and talk a little bit about the medical records custodian and their role in compliance. Um, I guess Jose, to start, you know, um, we can
Let's
talk
put it
about the
this way.
medical records custodian role. I guess we could
Yeah,
start
so let's
there.
let's put let's put it this way, right? So, what is the role of a medical records custodian? It's extremely boring. If you're a smaller office, it's a part-time job, if that, right? It really you're gonna find that there are certain specialties that you're truly needing somebody there all the time. And that's if you're a hub of a healthcare network or you're a primary care office or you're even a peds office, right? And here's why. You're constantly sending out records. Constantly. If you're a chiropractic office or a PT office that's heavy on the pit, you're going to need somebody that is a medical records custodian. And the reason is because you want to make sure that there is a clear track of who is getting access to these records, right? We all know HIPAA. If you don't know what HIPAA is, this isn't the podcast for you. Find out what HIPAA is, then come on back, right? Like we're not going to go into the preschool level of what these things, what these federal requirements are. What we are going to do is go over how is the best way to do this with limited resources, which every office and organization has limited resources, even the federal government, right? So, what is required of a medical record custodian? Well, you don't need a special degree. Yay! You don't need special training. Yay! You need to, one, understand how to send records, and two, understand how to receive medical records. And three, if an organization is treating us like crap, you can be difficult. And here's what I mean. There are certain things that you need in a medical release form, right? Depending on the specialty, there's basics, right? One, you need to know the patient's name. Two, you need to know DOB. Three, you need to have the signature of the patient somewhere that is giving that third party permission to view or store or receive their medical record, right? If a patient is coming in, usually this is their next of kin. If you're a peds office, this is their parent usually, or grandparent, right? Or their guardian. If you're in a primary care office or an adult setting or a geriatric setting, it could be the child of the patient. It could be the caretaker of the patient. It could be the spouse of the patient. Usually this is in your new patient paperwork, right? Perfect. Now, what we're talking about though specifically is a third party that's not mentioned in that new patient paperwork. So a lot of times this is legal, right? Or a patient is switching offices, so they would like their medical record, right? Perfect. Depending on how people treat you is how you treat them, right? Like it's really that simple. Most of the time this is very, very simple. Hey, I got this request. Hey, I sent it out. Perfect. Back in the olden days, when the internet made a lot of sounds for you to get on there, right? We would go and actually have a physical log. Hey, so and so picked it up, so and so got it ready, and you had a clear chain of custody. Now, with the advent of technology, yes, there are more paper trails in respect of I send out an email with this medical record. Hopefully, it's encrypted, and hopefully, the other side is a secure email as well. But we're not going to touch that right now. We still need to know who is asking for it, whether the patient agreed to it, and what is being sent out and when. Right. So, um, I believe if you have a compliance program, you should have a very, very simple log of something like this. Your medical records custodian usually can knock it out depending on the size of the patient record. Some of these patient records I've seen are larger than the King James Bible, but for most practices, it's going to be relatively small. You can knock it out in no time at all. The beautiful thing is that you can get reimbursed from the legal firm or from the third party if you so choose. And there's a cap on the quantity. I want to say is it 50 or 100 now, Ray? I want to say
Mm,
it's like a dollar a page. I can't remember off the top of my head. I'm blanking on it. Um,
used to be $1 a page.
yeah, it used to be a dollar per page, right? So, and I think there's a cap, like $100 maximum for the record or something like that. Point is this: if you're a smaller office and a law firm sends you um, a blank, a blank medical record request, you can do one of two things. You can throw it in the trash. Why? Because it's blank. I don't care if you have the patient name on there. I don't care if you have the patient DOB on there. I don't care if you have the patient signature on there. You don't have written down what it is that you need. I don't know if you need their med list. I don't know if you need their progress notes. I don't know if you need their imaging, their labs. Like this can get pretty extensive. So what you want to do is you want to have a very clear log. And then depending on, hey, is this my patient? And do I want to make things easy? I'll call them up and be like, hey, I need X. What do you want? And in order to do that, I need X. Most firms, most entities asking for medical information are smart enough now that they understand, yeah, okay, I'll get that paperwork out to you. Some of them are more stingy than others with giving the information out. Honestly, at the end of the day, if that misinformation is mishandled, whose fault is it? So that medical records custodian is if you have somebody that has a bit of a power trip, it's a perfect position for them. Perfect position for them because they have a very limited space that they can just execute however much power they want. And it's a very
Point.
clear guidelines. If the patient information is not on there, if what they want is not on there, and the patient's signature is not on there, that is not a request. It's not. You can just throw it in the trash, or you can call them up, call the organization up, and be like, "Hey, um, I can't give you this because of pick a reason, right?" Then when they send it back, you really should follow through because it's just continuity of care, or there may be some legal ramifications to the fact. Generally, there's a timetable. I've seen one lawyer, and this is wild. A lawyer actually sent us the request and demanded it by that Friday. This was Wednesday. I'm like, or else what? You're giving me 2 days. I told my patients 2 days for a
What's the
refill. You want
standard
me to
usually, or what's your
Yeah,
standard at your
the standard legally is usually 30
30
days.
days? Yeah.
Yeah, at minimum 2 weeks, right? 2 days? Pound sand. Now I'm not going to do it just because, you're forcing me to do it. You're trying to and the worst part was I don't have a problem with this. You're representing my patient. This doesn't really affect me one way or the other than the way that you're treating us. You know what I mean? Like this is one of those situations where if anybody has seen that old movie Waiting, you don't want to piss off the people that you need something from. It doesn't make any sense. But it is one of the few places where we as administrators are not the ones needing something from somebody else. Somebody needs something from us. So instead of us kissing, the insurance's butt or credentialing's butt or a pharmacy, no, they have to kiss yours. It's rather nice. It's a rather nice change of pace, right? Uh, so it's really a matter of you want to put somebody there that can do the job and that they notate everything. So this way, if something happens, we've had a situation with this before with HIPAA privacy. God, I just want to say the last time this happened was about 10 years ago. A consulting client of ours printed out or made a copy of the entire medical record for a patient.
Yeah.
We handed it to them in a manila envelope. The patient signed off for it. They put it in the patient took it with them and left it somewhere. or a piece of it got somewhere. And then they were shocked when, we were shocked as the consulting firm when our client called us and was like, hey, so patient forgot this somewhere and somebody just decided to mail this to us or drop this off. I don't remember how they got it, how they got the
Oh boy.
record back. And
Yeah.
I'm just like, you've got to be kidding me. Because the practice is freaking out because they're like, this has our name all over this thing.
So
Like,
it got
what's
mailed back to the practice
no,
by
I want to say that the person who found it brought it back,
okay.
rather than mailed it
I
back
was gonna
because
say, does that
it
make
would have
it
cost too
worse
much.
if
Well,
they
it would have
mail
cost
it?
too much. You know what I mean?
Right,
Like
right,
you're
right.
gonna mail something that's not yours for, like that's a lot
Yeah,
of effort.
it is.
Um, but they brought it back, and I was just like, holy crap. Well, I was like, do you have a log showing that you handed over the liability of this record to somebody else? That doesn't mean that you're giving the only copy away because you still have record retention rules you need to follow, right? But you handed off liability for anything that happened after I transmitted it to them.
Right.
So when the patient came back all mad because their record was missing and they didn't know what to do and this, that, and the other, it's nothing I can do. This is on you. I gave it to you.
They signed off on it too. So
You signed off on it. It's done. It's over. Now, another time we saw that there was a breach in actually a healthcare insurance broker's office. They had asked for patient information because that's part of risk and assessing risk and all that fun stuff, so they needed a copy of the medical record. Okay, cool. So another client gave that health insurance broker the record. Perfect. Because they had a log, they weren't liable for anything that happens on that insurance broker side. Because remember, they're not a business associate, so sending them a BAA does nothing. There's no way to hold them accountable other than the fact that HIPAA rules apply to insurance brokers and different and lawyers and things of that nature, but they don't understand it and they're not usually penalized for it. We are penalized for it all the time. So we need CYA on our end. So the health insurance broker ended up having to go to and follow through with all the HIPAA regulations and, hey, patient, I have to notify you that we had a breach. Your information could have been part of that. And, they had to go through that whole process. If you don't have that log and that patient's information is out there, that breach is on you. Right? So this is a this is probably one of the easier things to follow because the second you get a request, you just put it down on a log. You should have one log, one person that has access to it, one person that addresses it. So that way you make sure that all of these things get done and it's nice and clean.
that one
Right?
person should what? Be the HIPAA officer, HIPAA compliance
Person can be
officer,
the
or
HIPAA officer. I mean, it depends on the size of the office, right? Like it could potentially be HR, depending on the kind of office you have, right? Because it's not really something that I'm trying to think of a situation where you would need it. You would need to be a rather large outfit to need someone to only do medical records. I'm thinking because the problem is too, if so for example, I'm a mental health office. Even if I was a mental health hospital, we would have to be extremely large to actually need someone to only do medical records. Billing could handle this as well if you wanted to tag team it that way. Like your billing manager could handle this as well. And probably be a perfect way to vent frustrations because people misfill out these forms all the time. So what you want to do is you want to go and see how often are we getting these requests. I mean, we're mental health. I think we're getting them about once or twice a month. Primary care, depending on how often you refer out to new patients to new providers for that patient, could be relatively frequently. Because primary care, you're constantly just a hub in the
Sure.
wheel. All right, I'm sending you out here. I'm sending you out there. I'm sending you out here. I'm sending you out there. And they need that record. Normally, what you would do in that kind of a situation to preempt that is you would go and patients are also getting better about this too. They'll ask for a copy of their medical record and they'll keep one on them when they go to new providers so that way they don't have to constantly ask, because it's like asking for your college transcript when you transfer or graduate. It
Saves a lot of
takes
time.
forever
Yeah.
sometimes. And then it's not just forever in asking for it, but then it's forever in processing, and then it's a whole bloody thing. Anybody that's gotten out of the military and tried to get something done through the VA knows exactly what I'm talking about. Or if you're asking for something from or a medical record from the VA, good luck, right? So it'll be faster to get the patient sometimes to go and get that medical record and then bring it to you, and then you scan it and give it back to the patient and be done with it, right? Or they say shred it, cool, shred it, dispose of it however you normally dispose based on your policies and procedures.
How about a
So
question for you, Jose?
I have an answer.
What's your protocol at your practice? If you have a patient or a third party that maybe submits a incomplete medical records release form, or incorrectly
That's,
filled out,
I mean, and
I feel like that
it,
could
yeah.
that's could be a common,
So due to the
common
size,
issue.
due to the mental health nature of our practice, we normally have two protocols with two sets of people. Um, my front desk person, I've taught him the basics on a lot of this stuff. So he'll handle, hey, inter-office stuff. Hey, my primary care needs this, or hey, my neurologist needs it. All right, cool. Boom, bam, go for it. Right. Or hey, patient's going into the hospital or a facility, send it. Perfect. Those simple things. When it comes from a lawyer, he hands it to me.
I
So
see.
for purposes of officially, I'm the medical record custodian. And the reason for that is because we are mental health. They can give me a medical record request, but that doesn't mean that they are allowed to have everything in that medical record.
Makes sense.
Let's go over some of the exceptions, right? Ooh, buddy, exceptions to the rule. If you are infectious, anything regarding infectious disease, mental health, and what was it? Mental health, infectious disease, and even drug use I've been seeing is another a light exception, but it's not illegal
Hmm.
in most jurisdictions. It's mental health and infectious disease information. That information we can censor however we believe we need to censor in order to make sure that the patient will not harm themselves or others. So if we think that this information, so if a patient asks me for their medical record and my provider puts in there, not on the progress note or even within the progress note, but another side note saying, hey, be careful with such and such patient, such things trigger them. And we think that may trigger an issue, then we can completely just excise that out of their record to not give them to them. If this is legal or if this is a background check or if this is probation, right? Or even if this is a parent or a spouse, again, we can hold that information if we think it will be harmful to the patient or to the community. There's not a damn thing anybody can do about it. Because a judge, you can go in front of a judge, and we've had lawyers do this before. Lawyers will go to the judge and say, this is an incomplete medical record. And we'll be like, perhaps it is, perhaps it isn't. It's none of your business. Because if this is part of the exceptions, then
That
I
comes
can't
with
even
the
really
that
acknowledge
comes
it.
with the obviously the industry that you're working in as far as
Yeah, it comes with the subsection, but
yeah,
remember
yeah.
that this is also a situation as well where these kinds of exceptions also matter for the odd exceptions with patients, right?
No,
So I can
absolutely.
have a patient as soon as they're about 12, 13, even 12, 13, I'm gonna say normally for mental health, but honestly for sexual abuse cases, for sexual activity, infectious disease. Like there are certain things that I, as a provider, have to protect the patient. So even if it's their spouse or their parent, I may ethically believe that they deserve to know this information. It does not matter. I cannot give it to them, even if they request it.
You ever come across a scenario where a patient wants to revoke a previously signed release form?
Absolutely.
What is that, a
Absolutely.
revocation?
Yeah.
Yeah.
Yeah. It's extremely simple. It's normally more common on those scenarios where, hey, I got a divorce. Or
Yeah.
hey, I'm coming to see you, you know, this happens a lot with teenagers when they start seeing their providers, um, or they start getting contraception from their providers, and you start getting into areas that a parent could object to. As a provider, you have to have those conversations. Hey, if you are sexually active, these issues could come up. As a provider, they have to do their job and ask them the questions. You know what I mean? Now,
Right.
they can, at the request of the patient, not reveal the conversation to the parents. And this is where certain OB offices will just go and flat out say, hey, as soon as the kid's 13 or she's going through puberty, you're not in there unless the patient pulls you in because they want to make sure that they can have a safe space for the patient to be able to speak and talk about their health issues. You'd be amazed by how many providers are the primary line of defense against abuse because they find out the information randomly, right? It's not the ERs that are normally going to do it. It's normally the day-to-day providers.
Sure.
So that are finding abuse, whether it's elder abuse, whether it's child abuse, whether it's sexual abuse, spousal abuse, pick your poison, right? So we've got to be able to protect everybody. Now, in those scenarios, in we have discretion. We need to know and understand how to use said discretion, right? I don't want to use it all the time. We had one case in the mental health office where the patient was diagnosed with oppositional defiant disorder. Problem was, didn't get along with one of the parents. Cool, got along with the other parent, but the parent who the child didn't get along with had a better lawyer. So where do you think where do you think custody went to? Right? So it caused problems, behavioral problems that our office was like, okay, well, the parent that they don't get along with wants a copy of the medical record because they were going to try to leverage this with their attorney. And we only found that out after conversations with both parties. At first, we just saw, hey, look, the patient doesn't get along with you. You're, in our clinical opinion, the cause of the issue. We're not going to give you the record in regards to this. You can have the medical record in regards to what is being prescribed, so you know exactly how often the patient should be getting their meds or how often they should be in counseling. You know this, that, and the other. But we're not going to talk about the diagnosis or the cause thereof.
Sure.
Right. So it becomes it becomes a situation where we have to be a mediator without being a mediator. Right. That medical record custodian has to have a little bit of discretion with those fringe cases. But even if they don't have the knowledge to do something like that, they just need to be able to flag, hey, this is a wonky case. And then this is where they bring in the executive team or their consultant or the in-house legal and say, hey, what should we do here? Most
So
of your day-to-day medical requests are going to be basic and not even worth having a conversation over. Just do it,
I was
get
gonna
it done.
say, as far as training new hires and stuff like that, and new administrative staff on, what you can and cannot disclose, you kind of just nailed it there. As far as these types of situations, you want to bump that up the ladder.
Yeah,
You
absolutely.
don't
I mean,
want to,
just because I'm the medical record custodian doesn't mean I'm the owner of the practice, doesn't mean I have
sure,
a legal degree. I mean, I just
yeah,
went over the
yeah.
fact that you need no schooling, no certification, no licensing. I need to know how to read. You know what I mean? Like, I
That's
hate
it.
to say it, but I need to know how to read. Now, every office, every organization has a different copy of the same form. You just got to look for the same bullet points all the time. Name, date of birth. If they have a medical record number, perfect, because it makes it makes it easier for certain organizations to find the medical record. And then obviously signature and what it is they want. That's simple. It really, really is that cut and dry. Those edge cases make things interesting, and the way that people treat you make things interesting as well. I mean, 3 weeks ago, I told my office, if anything comes from this one law firm again, we are going to drag our feet the entire way, just because of how they treated the team. There's no reason for that. You're representing our patient. We're not trying to make things difficult for you, but if you can't even understand the basics of the conversation, then that's that, you know? But again, we're in an edge case because we're in mental health. If you're in primary care, a lot of times there's just be like, hey, the attorney needs this because they got into a car accident. They want all the records. Okay, cool. Now, if I'm a primary care office in that scenario, I'm asking, okay, maybe this patient's been a client of ours for 20 years. You want 20 years worth of records? Like I would absolutely. Do you really want all the records or just the records from the accident forward?
Yeah.
Sometimes they may say, no, I want it all. Okay, screw it. Send them a bill, bury them in paperwork. Let some poor paralegal, legal assistant, intern deal with going through all that crap. Um, a lot of times if it's for our patients, I try to be helpful just because I want the patient to be able to move on from whatever situation caused trauma that caused all these visits. If it's just
Absolutely.
provider to provider, I mean, we have gotten requests, not that often, but every medical office gets them. If you have a somewhat common name or someone punched in the wrong fax number and just switched numbers around, like even health insurances will send us wrong things. And be like, look, I can't honor this request for you because of X or because of Y. If it was meant for us, then all right, cool. But if it wasn't meant for us, then I'm just going to shred this. Again, if you want to make things difficult, you can go and be like, I'm going to inform the patient, blah, blah, blah. It's a dick move. You can. But I mean, for an innocent mistake, it's not really something that's worth doing. Have I seen it before? Absolutely. Absolutely. We had one client freaking out. Hey, our employee sent it to the wrong Dr. Park. All right, cool. Well, that office decided that they were going to inform the patient because this is a HIPAA breach and blah, 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 and it just started going down the list. And I'm
We're
like,
going
calm down,
down, going through
calm
the,
down,
yeah.
calm down. It's not that big a deal. Let's just retrain the employee. We'll inform the patient, hey, it was an honest mistake. They did receive the request, or even if, hey, my employee sent it to the wrong Dr. Park. Again, most people are going to be like, hey, you sent it to the wrong place. We don't have this patient. We're just going to ignore that we got this and shred it or just destroy it and be done with it, right? It's extremely common in the industry. We're not trying to be difficult. There's some places that are going to be difficult, and then that's when we got to go and kick in our protocols. We inform the patient, hey, look, this is what happened. We were following through with a medical request from Dr. Park. Our person just sent it to the wrong Dr. Park. They got it, they destroyed it. We just need to inform you of it. We apologize for any inconvenience this may have caused. We went ahead and sent it to the proper Dr. Park and we move on with life. Don't make it a big deal. It's like
Sure.
a kid that ran into a sliding glass door, right? Don't make it a big deal. Don't make it a big deal. You make it a big deal, they're gonna make it a big deal, right? So just relax, be cool with it. Ray, did you have a copy of the log that Epi Compliance
Yeah,
has?
I'm gonna share my screen shortly, and
So this can show you you can create a log or you can use one that your compliance program has
correct.
available to you.
And to your point, obviously, as a custodian, you got to maintain a system where record organization and retrieval, that aligns
Yes.
with HIPAA standards, and
Yes.
obviously that includes documentation for these release of medical records, and That's kind of where Epi compliance comes into play. One of the tools that we offer through our services is we offer a variety of templates, including these medical records release form. And again, our goal is to, help streamline these processes and essentially keep all these things in one place. So, let me share my screen. I'll sort of show you how that's presented here
This
on our.
log is not something that you should. It's like a Sharps log, right? Oh, hey,
Right.
somebody got stuck. Don't download a new one. Put one person on there and then throw it back up there. Wait for it to be pretty filled out and then throw it back up there because it's just going to be a log.
So this is sort of the guidelines that we provide, the policy on medical records, and then the medical release form templates. This is essentially what we provide our customers, just the generalized template.
Yep.
It's a downloadable PDF. If you have to make changes to it, you certainly can. If you have any sort of Adobe Acrobat, PDF editor, you can go in and edit those things. But this is very generalized, and
You
you can
want
all.
to make sure that information to be released, something is checked. Because if nothing is checked, you will have people that will deny the
You're talking
request.
about the information to be
Yes.
released is. Yeah,
Yes. Because you will have people that will deny the request.
no, absolutely. Um, but like I said, that's essentially how we present it to our customers. They can access this. This is a part of HIPAA privacy. We call this the forms and policy section, which again, the medical records policy is going to be in your policies column, and then our templates are going to be in your PDF forms or online forms area as well. So
Do you have the log for the medical record custodian, Ray? Do you have that readily available?
you said the log.
Yeah.
Yeah, give me just a second. I thought I had that pulled up.
If not, this is how you search on the Epic
Yep,
compliance
you can
system.
you can search these things too. There we go. Disclosures.
Yeah,
Let me just down and yeah, everything's a downloadable
should be that one.
PDF. We're gonna open her up. Boom, bada
Yeah,
bing.
see. Yep, there you go.
And this is the
So,
PDF version as well. I mean, you can locate this in online forms as well.
no, but I mean, just throw that back up real quick.
Yeah, yeah.
So this is what I mean by having a log. This is everything that you need to absolutely have. Uh, he took off. You guys took off the signature. Okay. There used to be when you needed it, you'd have a signature, but now since everything is done by fax or by email or whatever the case may be, you that signature part is gone. If a patient's picking up, I always recommend getting a signature that they have picked it up and you put it in their record just so that way you have it for CYA purposes. But if you're just going to be doing it just like here,
I know in the
it's not that.
online version of this, Jose, obviously, again, this is all being done through the system internally, and whoever the
Yeah.
user that's logged in and documenting, it'll track that information.
Okay.
Um, this is
So
more of
yeah,
the
so I mean,
printout version.
yeah, so go to the policy real quick. All of the policies that you have in a compliance program, you should have a default and then you should have customized version. The way I usually like to do things like this and recommend it is as you need the policy, you look at it. You're supposed to review it every year, and I'm gonna wink, wink, nudge, nudge. Know that you review it every year, but as you need it, you modify it. Use these as a template to create your own, and then just make sure that you train your people on what that policy is that's customized to you. So, for example, if you have a billing department and that billing department manager is your medical records custodian, then you say, hey, all medical records requests go to blank. And that person, is very familiar with the way that things are done when it comes to medical records, how they're sent out, how much is billed, invoicing, all of that fun stuff. The chain of custody, all that. So that way that's all taken care of.
Yeah,
Ugh.
absolutely.
So anybody got any questions about this? I don't want to beat a dead horse too much, but I think we hit the majority of it, right? We knocked out the exceptions, we knocked out the rule, we knocked out some best practices.
Yeah.
I don't, and I know that this is a thing, and I'm of the generation that I would want it this way. I am not a fan of emailing the medical records. And there's a
Would you
lot
say
of
that's
basic.
a, would you say that's a, I was gonna, well, one of the questions I was gonna ask is what is a common mistake that you see practices, make when it
So
comes down to this?
let me put it
Obviously
this way.
being on the consulting
Even
side.
yeah, so back in the day when faxing was just regular faxing, right? Faxing was a very safe way because it's end to end. Nobody's going to intercept it. Nobody's going to store it. Nobody's going to do anything like that, right? But now we have fax to email or fax to an ASP or fax to straight to the EHR or the practice management software or, pick a thing. But it's not a one to one. It's not end to end. And now there's like a mid stop that can be a
Sure.
hub that can be hacked. That's a HIPAA security issue that could come up, right? So you want to make sure that you have what is the policy, what is the procedure for something like that? What is the liability for something like that? Me sending information out. The second I send it to a patient, if I'm sending the medical record to the patient, it is the electronic version of me handing it to you. Whatever happens, that's on you, boo boo. But I did my part. If I'm sending it to another org, I really want encryption or I want to know that it's secure because it's my information and my liability until they accept handoff. When they accept that handoff, I can wash my hands of it, right? Like I don't and I see this a lot. Like I'm not a fan of practices allowing people to have company email access on their cell phones. I know it's convenient, it's extremely convenient, but it is awful if you're receiving or sending PHI. And it is common, very, very common
I think we talked
at the
about that
end
in the
of this.
previous,
Yes, we have. And it helps expedite things because like, oh, okay, I gotta put this on the list while I'm running around, blah, blah, blah. But it's not a best practice compliance wise. And again, it's always that seesaw. If I
hmm,
want to be extremely compliant with every single aspect of every single law, that information will never be touched the second it's created. It's thrown into a hard drive, and that hard drive is thrown in the Mariana Trench. No one's touching it ever, right? Uh, it's just not usable that way. It's not malleable. It's not movable. We need to be able to move it. So this is where you've really got to figure out what is your best practice. Hey, maybe we don't email. Maybe we set up a Dropbox or something of that nature, and you can pull it from there. I know accountants that do that with financial records. I know some larger practices set up something like that. You can do that with 365, and I think G Suite will do it as well. Don't quote me on it, but it's basically you set up a Dropbox and you give someone with a specific email access to it for a very temporary period of time. And if they don't put the password in that's time stamped and they don't access it within that time frame, it nulls out and you have to redo it again. And again, it's extremely secure, but it's a pain in the butt. Because if you're not set up for it or you can't do it or you use the wrong browser, depending on the product, it just becomes very, very difficult. But again, the liability is ours until they receive the information. The only thing that they can do is they can moan and groan about it, but they have to deal with it the way that we want to and we are comfortable doing, if that makes any sense at all for everybody. So again, I would say if you don't have a methodology of how you are transmitting, probably need to take a look at that. A lot of people are still faxing, which is fine. You want to confirm the phone number when you're faxing. You want to put a cover sheet when you're faxing. All the standard stuff that people just kind of do automatically now. Um, if you're emailing, you want to put it in there like, hey, look, this is specifically to this person. Don't just email it to acme.gov or acme1.com, at Google, at gmail.com or some nonsense, right? Like confirm the information. So, yeah, I
Absolutely.
mean,
And
that's
you could
that.
also,
I mean,
I was going to say, you could
go
also
ahead.
reach out to Jose or myself at Epi Compliance. Again, we've
I love
designed these resources to make it easier for healthcare organizations to, again,
I love
focus
hearing
on.
exceptions. I
Yeah.
love hearing
Yeah.
exceptions. Anytime there's an exception, it's interesting because then we get to sit down and be like, okay, well, yes, because this, but no, because that, and what supersedes what. It's a fun
Right.
little game that we play because it's complex because we as a healthcare industry have rules that contradict each other. But which one is more important? Sometimes the supremacy clause kicks in, sometimes it doesn't. Sometimes, you know what I mean? Like you have all of these different scenarios that just are, it keeps things interesting. So for me, this is the stuff that I love, the exceptions to the rule, because I get to critically think, not just follow a process because that is process. So cool.
Absolutely. Well, if
Well,
anybody has any questions or concerns, please feel free to put those in chat. We'll take the next minute or so to answer. If you guys have any topics you'd like us to discuss, as long as they're healthcare related,
yeah,
please put those in chat as well. Next week's topic, we're going to be touching on uh, terminate. So essentially what kind of checklist to follow when you have a terminated employee, as far as remaining HIPAA compliant and making sure that, we're revoking access, uh, on their way out the
we're gonna go
door.
through the voluntary and involuntary. So
Yes.
we're gonna go through both.
This was
Um,
suggested by a customer, by the way. So again,
oh, okay, cool.
if you have any topics you'd like us to discuss, please let us know.
Yeah. Yeah.
Always,
The voluntary
always,
versus involuntary. I'll tell you right now, the involuntary one can be a lot more hectic
I can,
because
absolutely.
sometimes you're doing it not when you are prepared to, but when the situation arises. So it's really important to have a strong checklist and be aware of what everybody, I'm going to put this, the exposure your practice could potentially have.
Absolutely. And I'm going to put our YouTube channel. That's going to, for those that joined, we'll be having this episode on our YouTube channel. It'll probably be sometime tomorrow morning or early afternoon. So just be on the lookout for that. Everybody that was here will receive some correspondence to register for next week's event. And I don't see any questions coming in, Jose.
Perfect. Means we punch in the
I'm,
face.
I'm assuming we
I'm
did a good
assuming we
job.
did a good job. Sounds good to me. Let's punch it.
Cool. Well, again,
All right, everybody,
appreciate it.
back to work.
Yeah, back to work we go. I appreciate everybody tuning in today. Hope you found this session beneficial. I'm posting on our YouTube channel here in the chat. If you haven't subscribed already, please like and subscribe. Uh, we've done over 72 episodes. I think today this marks our 73rd. We've been doing this since October 2023. Plenty of content in the catalog. So, like I said, please like and subscribe. There might be some topics that we've already discussed in there that might tickle your fancy. So awesome. Well, we'll see everybody next week. And Jose, I appreciate you as always. And
Yep,
looking forward to this one. Okay.
absolutely. Take it easy,
All
guys.
right. Oh wait, Jose, we got something. Oh, never
Oh,
mind.
yeah.
That was just one of our attendees said thanks for your time.
Oh, anytime, Jennifer.
Thank you,
Anytime.
Jennifer. Appreciate it. All right, Jose. Take care.